So in this video, I'm going to talk to you about private citizens and contracts and why your signature makes a contract which is outside of the Constitution and without constitutional or federal authority, even though they say it is with federal authority. Okay, this is a little bit longer than the last one I made. On Tuesday, the 23rd, Washington wrote to the Baron Steuben, "This is the last letter I shall write while I continue in the service of my country as a civil servant. The hour of my resignation is fixed at 12 today, after which I shall become a private citizen on the banks of the Potomac." So once he retired from the public life, he became a private citizen. And here we read in Washington and the American Republic on page 37, Washington, now a private citizen, hastened to his beloved home on the Potomac, accompanied on the way by many friends, among whom was Colonel Walker and such. "I am now a private citizen on the banks of the Potomac. I feel myself eased of a load of public care." So there's a difference between being public and being private. Being public is when you work for the people, and being private is when you're just doing your own thing, minding your own business on your own private property. You are private. He gave his farewell speech in 1796. So he retired shortly after that, probably, I'm guessing the following year, probably. So nullification. Andrew Napolitano has talked about nullification many times, and he has said that the same way in is the same way out. And this is good law, it's ancient law, it's common sense. It's the act of making void. Now they use this word void, which is interesting because it's written in the early documents of the country that an act outside the Constitution is void, not voidable, meaning it's invalid or as if it never were. Voidable means you have to go to court to have it voided, meaning whether or not it's constitutional has come into question. When it's void, it's absolutely on its face void. It's unconstitutional. The word acquired no rights in the English language, we believe, although nullify occurs in Jeremy Taylor, until it became necessary in our political history to devise a term which would signify the so-called right of one or more of the states in the American Union to declare a law passed by the national legislature unconstitutional and to refuse to be bound by such legislation. Now, it says states, but this definition, as you may be able to tell, was written long before the idea of instrumentalities came into use, where they contract with people in an individual capacity. So the states were groups contracted with the federal government. But nowadays, the federal government uses its instrumentalities because it can't constitutionally contract with individuals. It uses its instrumentalities to contract with individuals. And the instrumentalities claim that they have a constitutional right to do so. However, I would point out the ancient law, which states that when you give a right to your state or to the federal government, they cannot then give it again. So a delegated authority cannot then be delegated again, or an authority not delegated cannot be delegated. So they can't take something they don't have. So the instrumentality saying that the federal government gave them the right to do thing is an absolute lie. Because the federal government, if they had the right to do it, they would have done it themselves. They don't do it themselves. They have their instrumentalities do it. Their instrumentalities are outside the Constitution. I just wrote a few notes here. The way in is the way out. A positive mark is in, and then a positive mark would be out. If the way in is the way out, then if you sign to get in, you should sign to get out. It's not just for the states, it's for individuals these days because they have created instrumentalities since the banking laws of 1913. Okay, so contracts with individuals, that's what they do. Their instrumentalities are contracting with individuals to have you pay according to the non-positive or non-law title, Title 26, which is just the stipulation, the terms of the contract. A necessity of one does not deprive another of a right. So they may say things like, well, we had to because, or we had to because, or we had to because, you know, we were going bankrupt, or we had to fight a war, or it doesn't matter. They can't claim a necessity to deprive you of your rights. Okay, so we looked at a paper from a book. This is A Brief Introduction to Austin's Theory of Positive Law and Sovereignty. And you can find this book online. It looks like I probably got it from archive.org. That's where I get a lot of books, but also you can get them from Hathi Trust. So it talks about the positive mark. The positive mark is your signature. And here it talks about a man, a power over a person. Okay, a power over a person which cannot be exercised without that person's consent is no power over him at all. So none of us signed the Constitution. So in order to be under the Constitution, you have to join and become a member of the federal government. The Constitution applies to those people on the federal lands, according to Austin's theory of sovereignty. And Austin is quoted a lot in the law and the philosophy of the laws. And here we have another statement on positive mark. The bulk of the given society must be in the habit of observance or submission to a determinate common superior. Now, keep in mind, this is from English law, but we sort of take some ideas from it because law is mainly just philosophy and science. So some of it would apply here, but it may apply in a different way. So the bulk of the given society must be in the habit of observance or submission to a determinate common superior. Okay, so under the Constitution, the military is observant to the superior. They become members, or also the civil servants who become members are in submission to the superior. That's the way it works in this country. To be in submission to a superior, you would have to join the union as a member of the military or civil service, or you would have to contract with its instrumentalities. Whether that superior be an individual, like a king or whatever, or a certain body of individuals, like the Federal Reserve, this he calls the positive mark. So you have to do something to become a member of it, okay? Or you have to obey the laws to become a member of it. In this country, you're sovereign until you give up your sovereignty by either a contract or joining the military, which is another form of contract, or private contract with the instrumentalities. So in 1 U.S.C., words denoting number, gender, and so forth, we see signature or subscription. So I've talked about this a little bit in some of my other videos where their forms that they use are advertisements. Okay, they're offers. They're called several different things. Signature or subscription. So your signature or subscription. So you subscribe on the W-4 to give money to the federal government for as long as you hold that job or that position under which you write the W-4, because that'll have your employer's name and how much money you make and so on and so forth. Includes a mark. When the person, so individual, make the same, intended it as such. So when you sign their paperwork, given your mark, your signature, you're subscribing to continue giving to them a portion of your money. You do it individually, meaning it applies only to you. As long as you intended to do it, then that's your positive mark. That's your mark. That's making it a positive law. So when you sign their forms, you make it a positive law. It's your intention to do it. You signed it. That doesn't make it right, really. Not necessarily. So here in the Ancient Maxims book, which is this one, I've sectioned off a couple of things. Here it says equity, and there's a lot of different types of maxims you can read in these, and I think this book is also online. I think this is a forgotten book. There's a website called forgottenbooks.com. It requires a membership, but they've got all these old books on there. I get a lot of books on there, including books on Freemasonry and just all sorts of stuff. That's another one. It's like $8 a month. Equity does not supply the deficiency of those things which are required by positive law, required by contract, requires your signature. Okay, let's see. Commerce. So contracts are commerce. They're in commerce. They're tender. They're legal tender. Legal is fiction. The Federal Reserve notes are legal tender. They're contracts. They're papers, and that's something I couldn't find, but their updating of the titles requires them to state whether it's current or not. That's because their titles, when not passed into positive law, are basically the terms of the contract, and those terms of the contract are current, and so they have a currency, not necessarily a money attached or a value, but that's really what their contracts are all about, right? Getting money from you. The currency is the Federal Reserve note that they use, and the currency is the contract has to be current, and so it has a currency. It's a tender. It's legal tender. It's legal fiction. Legal things are contracts. So commerce, by the law of nations, ought to be common. So by common law is common sense. Unwritten law should be reasonable. Okay, and that's important. It's got to be reasonable. And not to be converted into a monopoly, which is exactly what the Federal Reserve has done. And it's done it through the federal government and the private gain of a few. So that's what they do. Walmart is a monopoly because they use the federal government and instrumentalities to gain an advantage in commerce. Okay, let's see, a mode of agreement overcome law. So your agreements are your contracts, and your contracts are the law. They become law. Okay. Let's see. Some people say that taxes on the 1040 are a donation or a gift. And here it says nobody is presumed to give a donation. That's because you signed it. So it's not presumed anymore. It's a matter of fact. It's legal evidence. It's hard evidence. You signed it, and now it's a law. Nothing which is against reason is lawful. So common law, common sense, it's got to be reasonable. Nothing is so natural as to dissolve anything in the way in which it was bound together. Therefore, the obligation of words is taken away by words. The obligation of mere consent is dissolved by the contrary consent. However, if you write on their papers no contract, they come after you, and they charge you a fee, and they do all kinds of bad stuff to you. So even though ancient law says that's the way to get out, is the same way you got in, you signed it individually, you have to sign it individually to get out. When you try to do that, they don't like it. They don't want you to do that. There is nothing so agreeable to natural equity than that everything be dissolved by that tie which it was bound. So saying the same thing. You get out the same way you got in. we arrive at the legitimate meaning by reasoning. So all of their BS that they try to pass off to us to get us to agree or to get us to believe that they're in the right is, if it's against good reason, then it's not good. It's not good law. Self-evident truths are not to be proved. Let's see. Things inherent to a person cannot be separated from a person. So nowadays they take your kids. They try to teach your kids about being a girl is really, being a boy. And they try to take your wages from you, which is your labor. So all of this really is just a way to steal from you. Stealing your labor by making it look like they can, or they had a right to, or it's the law, or it's part of the federal constitution and all this, crap. Reason is the soul of the law. Anything unreasonable cannot be law. That's just pure silliness. Let's see. I'm not sure which of these I was trying to take note of, but I'll just read them. The order of things is confounded if jurisdiction is not preserved in everyone. So everyone has a right to their own jurisdiction. I have a right to my place. You have a right to yours. If I'm on my property, that's my jurisdiction and I have a right to it. If I'm on your property, then I'm on your jurisdiction. And we can see that according to the federal government's own laws, it has a right to its jurisdiction. It does not have a right to yours. So the court having a right to settle disputes, the Supreme Court having a right to settle disputes between citizens, means that it has the right to settle disputes between citizens on federal lands, because that's where its jurisdiction is. It doesn't have jurisdiction off federal lands. Everyone is the ruler and empire of his own affairs. I think that was the one I really wanted to. Okay, well, obligations are taken away by writs, and the obligation of a mere consent is dissolved by a contrary consent. So the way you got in is the way you got out. That's what it's saying. So let's look at contract law. This is by William Brantley, and it's called Law of Contract. I think it said 1912. The point of showing you this is to show you that contract makes law. If you sign a contract, you made a law. And they say this is a way of saying it is the law's in the contract and the contract is the law. So when you go to these titles, let's see. See if I can find one. These titles on their OLRC website. For some reason, I can't find the website. The OLRC website where the titles are, you see the ones that are contracts are non-positive. The non-positive titles, the ones that are not contracts and are constitutional, are given a positive law citation, so they're law, but there's still only law on federal land. Part 1, and I'll show you the beginning of this book in just a minute. The nature of contract. A contract is the agreement of two or more persons. Now, they define person as a corporation. So a person can be an individual, as we saw in the Title I, Section 1, Title I, USC 1, words denoting blah, blah, blah. Signature, the person. So it could be an individual and it could be a corporation, by which an obligation is created between them. The essential elements of a contract are therefore agreement and obligation. So where are the terms of the agreement? They're in the titles that are not positive until after you sign their papers. Their papers are all mentioned in their titles. So for IRS, it would be Title 26, because IRS has a federal section for federal people, and then it has a section for non-federal people, which is by contract. under its instrumentality. So to know what a contract is, we must ask, what is an obligation and what is the nature of the agreement that gives birth to an obligation? Every contract is an agreement, but every agreement is not a contract. Agreement is the genius, of which contract is the species. Every contract is an obligation, but every obligation is not a contract. An agreement is the accord or consent of two or more persons. So remember, this is from 1912. So agreement just meant that you could agree to something, but once you sign, then it's a contract. The requisites, purpose of creating an obligation and which is sufficient in law to create is a contract. So let's look at that again. An agreement is the accord or consent between two or more persons upon a certain matter, such as your agreement to enlarge the military-industrial complex by signing a paper saying that you promise to give up a certain amount of your wages or income, which is made for the purposes of creating an obligation. So you obligated yourself to make those payments. Every time you got paid, they take some out. And which is sufficient in law to create a contract. Well, it's sufficient because it says so in Title 26, which is not a law. It's not a law because it requires someone to do a thing, which is to sign a piece of paper. Those pieces of paper are the W-4s, for example, and the W-4 is approved through the federal government for the use by its instrumentalities as an advertisement to contract. The existence of a legally enforceable right to demand that a person shall or do or abstain from doing something. 2, a person who possesses this right, who can be active subject to it or active subject of it. Another person who is under the obligation to do or forbear, who is the passive subject of the right, a thing to be done or forborne, which is the object of the agreement. A right is a power, faculty, or capacity which the law confers upon a man of doing, not doing, or exacting anything. Okay, this natural right. So the right to contract, they say, is a natural right, but the things in the contract are supposed to conform to the natural law. They're not supposed to go outside the natural law, because in the book of Maxims, it states clearly that a man cannot be compelled to do what's impossible. So just because you have a necessity doesn't mean that I'm required to perform an impossibility, which is to give you up a certain amount of anything I have so that you can be happy. Since law is a function of reason and justice is the foundation of the state, all those rights are enforced which the state considers should reasonably and in justice to both parties and with due regard to the public welfare be enforced. So joining the military is a contract, and they do it under Title 10. Here we go. This is it. It was here all along. So this is the Office of the Law Revision Council, United States Code. And Title 26, again, as I always show you, it's not a positive law. You can see because it doesn't have an asterisk. And if you search the word positive law or the phrase positive law inside the Internal Revenue Code, it only appears in reference to stating what a positive law is or to some other thing where there is a positive law. But it doesn't, Title 26 does not in itself have a positive law citation. There is no positive law citation for Title 26. Title 1 does have one. And I show this to you all the time. I think it's under front matter here. It says positive law citation, 1 USC section. That's what a law looks like. 1 USC, 2 USC, 3 USC, and actually 2 is not a law. So 4 USC. Title 26 is not cited that way. It's cited as Title 26 Internal Revenue Code or Internal Revenue Code Title 26. It can't be cited as a law because it's not a law. It's not a law until you sign the contract. So to go back up to this top title page, if you want to look up this book, Law of Contract by William T. Brantley. second edition, 1912. And there may be better books out there. This is the one that I like. It's pretty explanatory. It's easy to read. It's easy to understand. Okay. Contract makes law, and law makes contract. The law is in the contract. So the law stated in the contract makes it a contract, and then the contract is the law. And you can see here, Title 26, having no positive law citation is not a law. So how is it a law if it's not a law? It requires you to place your positive mark on the forms, such as the W-4, where it's not stated as a law. Title 26 is not stated as a law. However, once you sign it, you make it a law. You make it a law for you.